All right, how you doing? Welcome back to Uncivil Law. Hope you're having a great day. We turn our attention once again for the Karen Reed Stupid. The Karen Reed Stupid is in full force because we have gotten into the thrust of the case, the investigation. We started off strong as the prosecution, started off with a lot of good witnesses, a lot of people saying, I hit him, I hit him, I hit him. These powerful admissions, if you want to interpret it that way, these really powerful statements. Got a lot of witnesses saying that. Jen McCabe in all of her glory, sure. And now we're starting to hear from the state's prosecution investigators. And we've heard about the leaf blowers, the stop and shop bag. We've heard about the solo cups, the uncovered things. We've heard about some of the stupid, but only a taste of the stupid. And now we just get to go through all the investigations and all the portions of the trial, and we just have to figure out where is maximum stupid, which is probably Proctor. And then, of course, the looming question that haunts us: when will Proctor be called? Because again, I feel like you have to call him. How do you not call him? The defense is going to call him if you don't, right? I mean, you got to call him, right? You got to do it. It's going to be ugly. It's going to be messy. You don't want to do it. You don't want to do it as a lawyer. You don't want to call him, but what can you do? You're stuck with him. He's just a big turd. He's a big turd. And all you can do at that point is just do everything in your legal muscle to try to polish that turd to a shine. And with Proctor, that's really challenging. That's a lot, man. That's really hard. How do I make this turd not be such a turd? That's really, really challenging. And so, but you got to do something. You got to try, because if you wait for the Commonwealth or wait for the defense to call him, you know that they're going to make him look even worse, and that's just unfortunate. And so you kind of have to, unfortunately, call him, and yeah. So all that good stuff, and we are just waiting for the trial to start, as we are joined by Spinny Fan. Spinny Fan is best fan. Don't forget to check out that Spinny Fan merch in our merch shop. We got some great Spinny Fan merch. And thank you for those guys, for those of you who send me pictures of your merch. I get pictures occasionally from some of you guys who purchased the merch. And you say how happy you are with the merch. So I'm glad that you're liking it. So that's awesome. Apparently the company that they use to print the shirts is a really good company. Apparently they're like the best or something. So I'm glad we picked someone that was good. So apparently for your silk screen t-shirt needs, apparently we have the best or something, someone said. So that's nice. Good morning, everyone. Yeah. And then of course you have to say, yeah. And then as the defense, your first question is like, Mr. Proctor. So why Mr.? Right? You don't even really care. I know it's an open-ended question, but you don't even really care what the answer is. So it might be the exception to the rule, right? That would be the first. I'd be like, good morning, Mr. Proctor. Good morning. So I can't help noticing that I called you Mr. Proctor instead of Trooper Proctor. Why do you think that might be, Mr. Proctor? Why do you think I called you Mr. Proctor? See if I could get him to answer that question, because I don't really care what answer he gives me. Any answer he gives me will be great. So I might start with the open-ended question just because I want to see the guy flounder around. I don't really care what he says. I made some mistakes in my life, and I'm no longer a member of the force or whatever. It doesn't really matter. I'll ask all the close-ended questions I was going to ask anyway. Like, isn't it true that you were dishonorably discharged? Isn't it true that you were dishonorably discharged, at least in part because of this case? Isn't it true that you're a tool and a liar and a scumbag? I'm still going to ask all the close-ended questions anyway. So I think I start with the open-ended question because that just sounds like fun. Yeah. Mr. Proctor, how are you employed? Yeah, exactly. There's a lot of interesting ways to go about asking that question, Tony. You've got the spirit. You've got the spirit. Save that revelation to revelation to the end. No, No, I think you want to get that out early and figure out ways to remind the jury throughout. No, I think yeah, no. No, I want to get that out early so that everything he says is full of disgrace. I'll figure out ways to ask it at both the start and the end of the trial. I'll figure out ways to ask the same question twice. But no, I think I want to get that out early. Get that out early and get the stupid going. The dissembling right off the bat. Did I miss much yesterday? Well, you missed the start of the stupid. We got the stupid and we missed the solo cups and leaf blowers and rakes and shovels and you missed the start of the stupid. So there's that. Yeah. Chat. What will Mr. Proctor's answer be as to what his current employment is? Wrong answers only. I like this question, Jinx. This is a good question. Wrong answers only. What is Mr. Proctor's current employment? This is fun. Jinx has the spirit. Let's get that party started, man. Disgraced former Trooper Proctor. Yeah. Dishonorably discharged Trooper Proctor. Yeah. Apparently, we also have a bingo card that also has pictures now. For those of you guys who like to play bingo. Incidentally, by the way, Mandy, would you do me a favor and pin the Twitter link for today to bring attention to the channel? We need to get those likes and reshares up. So if you'd be so kind as to pin that for me, I'd appreciate it. I thought I did pin it, incidentally. Did someone unpin it? Oh, there's Rose's. I'll just pin Rose's comment. There we go. That solves that problem. Yeah, we got uncivil bingo. Bingo is fun. All that good stuff. Tell your friends. I didn't sleep very well last night, so I'm running on deprived sleep and caffeine. Let's go. He operates the spinny fan. There's no way Proctor operates the spinny fan. It is way too reliable. I would not let Proctor within the spinny fan. No. I'd sooner let Proctor be a daycare worker than guardian of the spinny fan. I care about spinny fan. Good times. Yeah, the spinny fan emoji is pretty good. Thanks for all our mods for helping with creations of emojis and stuff. I don't really have a good eye for that, so I do really appreciate it. Oh, by the way, this will be a nice comment to the mods and also just to anyone in particular. By the way, if you happen to see like little clips of the trial, like especially if they're under 60 seconds long, if you see like little clips of the trial, if you can provide those clips and provide me like the link in Discord or something, then we can repurpose that for shorts. And that'd be good. So if you happen to like see 60 seconds or something that you can repurpose, that'd be nice. As we're trying to figure out new ways to bring attention to the channel, more shorts seems like a good idea. Proctor's a background actor in films that don't get any action. Proctor as a potted plant. I'm sure he'll fail upwards. What will his next career be? That's a good question. That's the real question. What will his next career be? Garbage man? Janitor? Work for a different police department? ATF agent? They hire some characters over in ATF. Maybe he can be an ATF agent. He's a little too old for the academy, though. I don't think they'll give him a direct report. Peak Hedseth. Lucky will be called again. Of course, Lucky's going to be called again. 100% Lucky's going to be called again. He's a great witness for the defense. Of course, Lucky's going to be called. 100%. No doubt in my mind. Proctor has a solo cups only account. Could be. Do I think the Fed investigation is going to come in? It looks like the Fed investigation's closed. That could be due to a lot of things, not the least of which is the change in administration and change in administration priorities. But yeah, it looks like the Fed investigation's closed. It's also not particularly surprising because the Fed's jurisdiction here is fairly limited. And also the Feds are very conservative in bringing charges traditionally. So it's not particularly surprising that it didn't amount to anything. It also could be, incidentally, that they're holding off waiting for this trial to come to a resolution because the Feds would, all things being equal, like to not interfere with a state level criminal proceeding while it's ongoing. So all things being equal, the federal government would prefer to not do that. Yeah, so it's on their please try to avoid list. So it could also be that. But could also be just the Feds decide not to bring charges for any number of legitimate reasons. It also would be largely based on who the U.S. attorney is right now. And, their directions, if any, from the attorney general. Because the U.S. attorney basically runs the office. That's their job. So, it would depend on, what their priorities are, whoever that is at the moment. What the Fed's charge would be? The Fed's most likely charge here would be for misusing color of office to deprive someone of civil rights, 18 U.S.C. 241 through 243. It would be charges against the police for deprivation of civil rights under color of law. Would be the most likely charge. There's also, of course, the inevitable, ubiquitous lying to a federal official. That's always a really popular one, 18 U.S.C. 1001, for any lies they might have told the FBI. The FBI does love that one a lot. That's always good. Will I do a giveaway today? You bet your ass, Jinx. Let's do a giveaway today. All right, what should we set the threshold at today? Well, last time we did 500. Let's do 550 as a giveaway today. And that way Jinx can create a fun thing for us to do. So when we hit 550 likes today, we'll do a giveaway. That sounds fun. We'll do a merch giveaway at 550 likes on this video on YouTube. So tell your friends, and we'll do a merch giveaway up to $20 in value. Void where prohibited by law. See store for details, so forth and so on. We could also do it based on the Twitter count. What would be a good number for the Twitter in terms of likes and relikes? We could do it as an either or. That'd be good. But then I have to figure out what number makes sense. I don't know what number makes sense. Is 100 too many for likes and relikes, or for not likes, but for comments and retweets? So is 100 a good number for retweets / comments? 550 seems like a reasonable number for YouTube, but I don't know what a reasonable number for Twitter is. 75? 75? All right, let's give 75 a try. So we'll do it as an either or. But someone's going to have to let me know when one of those two things happens. Well, I can watch the YouTube thing so I can keep track of that. So we'll go for 75 retweets. Yeah, 75 retweets, let's call it, and just make it that easy. 75 retweets. And we'll just count it as retweets only. So retweets only, 75 retweets, or 550 likes on the YouTube video, whichever comes first. And we'll do a giveaway during the break that follows that threshold. We won't do it in the middle of testimony, obviously, but whatever break naturally fouls after that, we'll do it during that. You're not on X? Well, now would be a really good time to get on X. Then you can help with the metrics. Help with the retweeting, bring attention to it, and so forth and so on. I say again, this is a self-correcting problem. The people who say they're not on X, this is a really self-correcting problem. You can join X and then you could retweet. Don't tell me that you're not on X. This is a problem that you can solve. And if you don't want to solve it, I mean, obviously you don't have to, but if you want to help, that'd be great. If not, then I guess that's okay too. But you can always hit the like button here, but you don't get anything for it. Well, you do if we get 550 likes, but whatever. You're banned? Well, that's unfortunate. In that case, in that case, you're just going to have to like the video extra hard here, I guess. I don't know. Or tell someone else to like it, tweet it for you. I don't know. You don't understand how this woman's on trial? I don't really understand either, given the shit show of a case. I understand how the state has enough, how they don't have a sense of losing face to bring this case. I really don't need to hear how you won't do X. Please stop telling me. If you don't want to do X, that's fine. But I mean, I'm setting the goal, so it's 75 retweets. If you want to help towards that goal, great. If not, then that's fine too. But it is what it is. So one of those two things, please. I asked. I don't recall asking why you didn't want to use X. I don't recall asking that. I remember asking what would a reasonable number be for the goal. And then Incidentally, by the way, Jinx, if you haven't already created one, you're going to have to create me a giveaway thing for today so that I have something to play so that we can do that. Spinny fan spins for justice. Spinny fan spins around. Spinny fan spins for justice. I wish my microphone wasn't sitting right here. The only reason it's sitting right here is so that it looks nice in the camera, but then it kind of blocks my view of the chat where the chat is. So it's like I either have to move the chat or I have to move the move the microphone. I can't move the microphone because I need to look nice on the shot. Do you guys only ship within the US? I don't know where we ship to. I honest to God don't know. Which is one of the reasons it's like void where prohibited, right? It's like, yeah, I don't know where we ship to. I'm not sure. We've never tried to ship outside the United States. I don't know. Yeah, I don't know the answer to that question. We could make it available only for US only, I suppose. We could make the contents US only to solve that problem. Probably for the best anyway on shipping costs, just to make it US only. But I'll tell you what, if we ever have a problem with it, we'll readjust as we go. If you win and you're from outside the United States, we'll figure something out, I guess. Assuming it can be shipped to you. If it can't be shipped to you from fourth wall, then I guess you're just out of luck. Which is again void where prohibited. So yeah, it has to be able to be shipped from fourth wall because that's our provider. So if they don't ship to you, then well, yeah. I suppose at that point, what you could do is you could buy it yourself, and I would compensate you up for $20 worth of value. I could PayPal you $20, so I could do it that way. Although you'd be responsible for the shipping. Yeah, we'll make something work. What's my opinion on the Idaho 4 case? You mean the Koberger case with the stabbing? I find the evidence in Koberger a little unsatisfying for my taste. I find the current evidence as currently available, and there might be more evidence that they're not providing, and I hope there is. But I find the current evidence a little too circumstantial for my case. There's taste. There's nothing wrong with a circumstantial case, but it is a quadruple murder with the death penalty, and so I'd like some assurance. And for my taste, I find the case as currently explained a little too circumstantial. I find it a little too speculative. Now, maybe, when it's actually presented in court, maybe it sounds different, or maybe there's other evidence they're not telling me. That would be really helpful. But I find it a little too tenuous for my taste to convict him and sentence him to die. I'd like a little bit more assurance, please. So yeah, I find the Koberger case a little tenuous for my taste. It would be really nice if the victim's blood was in his car. That would be nice. Or if there were additional, if his blood was elsewhere in the house, because all I'm aware of, is his touch DNA on the knife sheath that was left in the home. If he left fingerprints or blood or hair inside the house, or like a footprint, or the victim's blood in the car, would go a long way towards.
So I'm told counsel wants to see me as the jury's coming over. Why don't you come up to sidebar?
I assume, by the way, you can hear the court, by the way. Just double checking that you can actually hear it. And of course, we have a sidebar. Yeah, so I find it a little tenuous. We have a car that kind of looks like his car we saw on camera in the area. His cell phone was kind of sort of in the area and was also turned off. All right. We have Amazon purchase history where he was purchasing things and apparently an attempt to delete his Amazon history. It's like, okay. So, I mean, there's a lot to be suspicious. I've heard rumor, for example, he was seen stalking the property. I'm not aware of that, but someone said that in a chat, he was stalking the house a number of times. I'm not aware of the evidence supporting that. But if there's a lot of evidence of him stalking the house and surveilling the house, that would go a long way towards it for me. It would really help, by the way, if additional things of his blood, his fingerprints, his boot prints, his hair, skin was left in the house, or the victim's blood was in his car. That would go a long way. One of those things would be nice. But at the moment, I find it just a little bit thin. Great. You can hear the court? Outstanding. Fantastic. So all my audio things worked. Great. Fantastic. So we got the audio things on with a little noise reduction. So hopefully it'll be just a little bit clearer today. It won't be monumental, but just that little bit extra better, hopefully, audio quality for you guys, because I care. Yeah, it's a little thin for the quadruple knife murder with the death penalty. And again, maybe the state has more than they're giving on, which would be perfectly reasonable. The state might be holding quite a lot back. They might have a lot more than is currently known to the public. Wouldn't surprise me. They're not supposed to try their case in the public eye, remember? So the things that have come out have kind of, arguably inspired themselves. Apparently, Fourth Wall ships internationally to the UK, EU, Canada, Mexico, Australia, and Japan. So if you're in one of those countries, then I guess we can ship you a thing. Otherwise, maybe not. This is the new PC build. Yes, the new PC build is working fine. It's working great. Thank you very much. I'm very, very happy. It's working great. And I got a little cart for it, so it gets it off the ground, which was nice because I was concerned before that it was suffocating on the floor. Because of the carpet, I was worried that was suffocating. So as long as I changed out the power supply, I also got a little metal cart that has vents in it, vents in the bottom. So, that it brings the entire PC off the floor. And then also the thing itself is vented to help with airflow. So I get some nice airflow. $20 saves myself a hassle. For most jurors, touch DNA is all it takes to convict. I'm not saying you're wrong. As to what the jury will believe, well, we'll be in a better position to assess that once we, watch the case. Of course, I'll judge the case based on what's presented at trial, for better or worse. Maybe the case falls apart. Maybe it gets worse at trial. But we'll judge the case based on what happens at trial. We will almost certainly watch it and stream it, I imagine. So we'll watch it and we'll assess. They have to give the defense whatever they have, and they have been doing that. I can't speak to what they have or have not been doing to turn over things to defense. I can't speak to that issue. So I don't know that, and because I haven't been keeping my ear to the ground every step of the way in Koberger. I watched that last hearing they did and found the state's case to be even thinner in some respects than I thought. It wasn't that we saw his car. We saw a car that could have been one of 5 model years. It was like a 1991 to 1996. I was like, oh, it's one of 5 model years. Okay. So it's not his car. It's a car that vaguely looks like his car. Okay, that's promising. Yeah, that kind of the evidence against him is, there's enough evidence to suspect him. There's enough evidence for probable cause, but beyond a reasonable doubt certainty, I'd like a few more gaps filled in. Ideally, would be nice. The lighting looks great today. Yeah, well, the sky's doing what the skies do. It's overcast today, so that helps with the lighting. And touch DNA also is not like my personal favorite DNA anyway. I find touch DNA, again, scientifically, I find it to not be as reliable as other kinds of DNA. Plus, of course, the touch DNA itself, the transfer mechanism is a lot better. So first of all, it's just easier to have. And second of all, I just don't think that again, not necessarily my field, so I could be wrong on this area, but my perception is that touch DNA's scientific reliability is not as good as other kinds of DNA. That could be a mistaken impression, but it's my impression. So, yeah. Not to say that, it's not like garbage, but I'd like, something more would be nice. Then, I found touch DNA on the button of the knife sheath. That's a little thin for me. What camera do I use? I use the Sony Alpha 5100, I think. I'd have to double check. 4600? One of them. I use one of the Sony Alpha cameras. Not sure which one. It's one of the older models. It's a discontinued model, but it works great. It only does 1080, but I only need to do 1080, so it works perfectly fine. And I'm just using a kit lens right now. I used to have it on a prime lens, but I didn't really like it, and we're back to the kit lens now. I think it's on my Amazon page. I don't know if my Amazon page is still tagged in my video description, but if my Amazon page is still tagged in my video description, it would be listed there. I want to say it's like one of the 5,000 models, Alpha 5100 or something like that. Sounds vaguely right. I got it for $200 on Craigslist. It works great. My microphone was more expensive than the camera, which is pretty funny. Yeah, I don't think we need 4K. I think 1080 will be just fine. Also, when we use Restream, at least in the browser, we can only do 720 at that. I don't think we need Uncivil in 4K. I think 1080 will be just fine. Yeah. I think the camera only does 1080. I think 1080 is sufficient. Yeah. "4K would also eat up more bandwidth." That's it. True. Yeah. I think we're fine with 1080. That's fine.
You are unmuted.
Oh, Michael Proctor's in the house. Oh, baby. If we're getting Proctor today, I'm excited, baby. I'm here for it. If we're getting some Michael Proctor, it makes sense. It makes sense. So the objective now is to try to get Proctor on and off the stand, and also have some other witness before the weekend, so we don't have to end on Proctor. If you're calling Proctor to the stand now, you have to get Proctor off the stand so you can call another witness before the close of business on Friday. You got to give them something else to wash the taste out of their mouth. And if you're the defense, you want to do everything to prevent that from happening. So calling him on Wednesday, I don't know. It makes more sense. It would make more sense to like call him on Friday, probably, and then like go over the weekend because you can control the direct, and then like pick up the cross on Monday, or call him on Monday. Don't ask me what the random vibrating noise, by the way, is. I don't know what that's all about. That is not me. I don't know who has an electronic toothbrush, but it's not me, okay? Who has a pager that's sitting on a hardwood table? Someone pick up the pager from the desk, please. These random noises are brought to you by Uncivil Law. It makes tactical sense to call Proctor in the middle of the case. I'm not sure if it makes sense to call him today. You have to get him off the stand and get another witness. Ideally to completion would be nice. So you have to get through him and also some other witness to completion would be nice before the weekend. You can't have Proctor be the last thing going through these jurors' minds on the weekend. That's just a no-go area. If you, either that or call him on Friday to stretch him on, or call him on Monday. Don't give the jury the weekend to think about it. That's just bad mojo, man. Can Proctor plead the fifth? Well, if he were going to plead the fifth, he would have had to tell the court about it, and there would have been a hearing relating to that. So it seems like he's not intending to take the fifth. So the answer is, first of all, no for procedural reasons. Second, almost certainly no, because he'd have to have exposure, which there doesn't seem to be any. And even if he did invoke the fifth, you could just read his prior testimony from the record, because his prior sworn testimony. If he took the fifth, he'd be an unavailable witness. And then you just look at the rules for unavailable witness, and you just read his testimony from the record into the record. So yeah, he's not going to invoke the fifth. Not to even say that he necessarily could. He'd have to have criminal exposure. And like, what would that be? So, no. I'm going to go with no. Probably not. Nate the lawyer's here. Hey, Nate the lawyer, it looks like Proctor might be in the house. People are saying Proctor is here. If Proctor is going to be on the stand today, you should be on stream for this, Nate, because Proctor is just the best of glory. The prior link I gave you, I think, still works, by the way, if you want to join the stream. You can't read it without meaningful cross. Well, there was meaningful cross at the prior trial. He previously testified at the previous trial, during which both parties, there was meaningful cross. So yeah, no problem. There was a trial. There was a trial 1.0, Nate. Yeah, there was cross. I was there. That's fine.
Judge, while we're waiting for the jurors, just for the record, I think Ms. Little had an opportunity to review the redacted exhibits from yesterday, and I don't think there was any objection to them.
That's correct, Your Honor.
All right, thank you.
Would all rise, jurors enter.
More random. Yeah, this is good, Nate. Nate, the lawyer's here. Nate.
Hey, what's up, bro? Yeah, I don't think they're gonna be able to read that thing. And can you hear me?
Yeah, I can hear you fine.
Oh, hold on. I'm like hearing myself because I have you on stream too. No, I don't know about the meaningful cross piece of this though, bro, because I've seen it happen so many times in trials that I sat and watched while I was at the DA's office. If the witness is unavailable, even if they did testify before, the defense has it's like almost impossible.
Beverly Canoni, the Justice of the Superior Court, holding indebted within and for the County of Norfolk. Granier.
But in this scenario, it would be the defense themselves asking to be read into the record because it was the state's witness. So the lack of opportunity to cross would be something the defense would invoke.
You're right. You're right.
They wouldn't invoke it because they're the ones who would be asking for it.
Yeah. So you're right. So you're right in that instance. I thought it was the prosecution trying to get something read in. I'm like, that's going to be very, very hard because the first thing we're going to do is confrontation clause. Well, so what? I should be able to
presence and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
God save the
All right, good morning
Commonwealth.
again, counsel. Good morning.
God save us all, baby.
The Commonwealth.
I have to ask you those same three questions. Were you all able to
So we're either
follow the
in
instructions?
Massachusetts,
Discussing this
Kentucky,
case with
Pennsylvania, or what's the fourth?
Virginia, baby.
Virginia.
Were you also able to
Four
follow the
commonwealths.
instructions and refrain from doing any independent research or investigation into this case? You want to say yes or not, or affirmatively? Did anyone have?
But you know, officially, they're known as states.
About this case?
Like in the federal, they're actually known as states,
All
but
right, Mr. Brennan,
colloquially
next
it's
witness,
commonwealths.
please.
Thank you, Your Honor. The Commonwealth calls Connor Keefe.
Not yet. Yeah, I mean, it doesn't matter. They just like to be different.
Yeah, it doesn't matter. In the U.S., in the Constitution and everything, they're known as states, but locally they call themselves commonwealths. And Commonwealth was for everybody, not the King's wealth, but the Commonwealth.
Ah.
So everybody owned it.
That makes sense. All right, Connor, who are you?
Step up, raise your right hand. Thank you, clerk. Thank you.
You raise your right hand. Do you solemnly swear the evidence given to the court and jury in the case now and hearing should be truth, the whole truth, and nothing but the truth, so help you
So help you God.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I
I
work
thought it was
for the
Keith, like with
Massachusetts
normal
State Police.
spelling.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes,
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the Academy.
How long was the academy?
Approximately
You see,
6
it's
months.
Massachusetts State
Did you have any
Police.
further training
Commonwealth
after the
of-
academy?
They use it so
On the job
interchangeably.
training?
Yes.
Yes,
Commonwealth
in
Police.
various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the district attorney's office.
Did you have a role in investigating this case?
Yes.
Were you a assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes.
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to grade key and doing the extraction?
That
22. Were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag.
And why would you do that?
To secure it.
Well, more to the point, why would other
How
people
would you
not do
become
that?
aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
I
Yes.
see a suspicious amount of grass for this
74A,
blizzard
please.
that was supposedly happening.
74B? Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
I like how they put the gloves on in the courtroom.
Please, thank you, Your Honor.
It's
Ms.
something
Gilman,
about
take
it that is, I don't know, slightly odd to me. You
With
know,
the court's permission, I'm going to move this piece of evidence,
Yeah.
item into evidence.
like the evidence is in this super pristine state at this point. I'm like, I don't know, man. The gloves are, what are the gloves doing at this point? See, this is an evidence
Yes,
bag. See how,
questions
see it
you
has
can open.
red tape on it?
Stand and
It
show
has,
that bag.
it has,
red tape
look,
on
it
it.
has
What's that
the
for?
word evidence on it, and it has places where you
secure
can
the
write
bag.
things on it,
Closed.
and then it has evidence tape, and it
Bag
looks
is
like it has a
open. It's gonna be
barcode
taped.
on it.
Yes.
Whoa!
Do you write on the outside of the bag?
Yes.
Why do you do that?
to memorialize the date, time when the evidence was collected.
Oh,
open the
that's
bag and show us
nice. You
what's
write
in it?
things on the bag so you know where it's from. You're muted, by the way, Nate.
There it is, sir.
Yeah, there you go.
Yeah, it's the chain of custody. You have to write like I had it at this time. Then when you give it to somebody else, they got to sign it and so forth.
A,
so
cha-
forth.
a chain of custody.
Yeah.
Well, some of the people at the state police have not heard of this concept. Could you tell us more about this so-called chain of custody, like a record of who had what when?
Yeah. Who handled the specific piece of evidence?
Oh, you think that might be valuable in some way?
It should be. It
Okay.
should be. Well, but it just makes sure that whatever the evidence is, it hasn't been tampered with in a certain way or whatever. And that's why I usually have it locked up in the evidence room, which is guarded 24/7. You can tell he hasn't had a lot of thing open in these bags.
With the court's permission, can he show the items?
Yes.
But it's funny because I know we used to have just brown bags, and you could just write on the brown bag. But you would just see like it would be written like it was a piece of paper. This.
Nike getting their spot here for their promotion.
Hey,
Just do it.
Get your checkup right there. That's right.
Trooper, is that the same item that you found that night?
That's a nice shoe too.
Yes, sir.
It looks nice.
Placed back in the bag?
Looks like it's in good nick too.
An exhibit?
It's good.
Very little worn.
Objection, Mr. Chairman.
Where? What brand? What exact model of shoe is that? I want that shoe.
shoe
Anyone
would be-
identify exactly what model of shoe that
It's
is?
like a slip on.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who was collecting it.
Yeah. Simple chain of
Time that
custody
you write in the
procedures.
bag, is that the specific time the item was
I like
found,
this guy's
or does
tie.
that represent a
This
different
guy
item?
has the nicest tie
That could
yet.
represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that could be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75.
Why? Why would you?
That's a good question.
Uh,
We have a time travel
12 to
division,
75
so
acres.
sometimes we have to write dates in the future.
Do
It's
you recognize
complicated.
that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please.
so this is the process of putting all
recognize
this in
that
the
item?
evidence
Yes.
to the jury.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please?
So for those of you who
Take
don't
that down,
speak
please. Thank you.
trial speak, here's the evidence. We found it at the scene. Here's a picture of it at the scene. Do you have it here? Yes, we have it here.
I mean, that's
Now-
usually the steps you do to
Yeah.
authenticate it,
Now,
right?
yes.
You
To
found
show
this, right? You
found
found
it.
it here, right? Is this the item? Yes. Can you show us the item? Yeah.
Is
That's
this-
that's normal authentication. That's
is
how
this-
it's supposed to go.
Is this the bag that you?
Yeah.
Is your signature on the bag? Yes. Okay. Open the bag. Is this the item you placed in the bag? What is it? This is the
Yeah.
piece of evidence.
And normally there are answers
move
to the
on.
questions and not so much like what,
yeah.
who, what.
But it's just standard. And then all this stuff goes in the, well, and so it all depends on which state you are, but all this stuff goes into the back with the jury, and they get to play with the shoes and, you know, all the other evidence and determine whether you're going to be found guilty or not guilty.
Little pieces of tail light coming out of the bag. Exciting.
Now, was her taillight damaged?
Oh yeah, but when is a major factor, of
Well,
course.
if you got the pieces right there by the body, yeah, you know, you got
Her
to
taillight was
Sir, on
definitely
those
her
items,
taillight
are
was
there
definitely
stickers? Did you
damaged
put
at
the
some
stickers on
point.
them?
From what,
did not.
Do you know
due
where
to
the
what,
stickers come
and to
from?
what degree is very
Well-
much a dispute.
But I'm saying, at least you're close to
Do you know
putting
if
her
these
at
items
the
were
time at
ever
the scene.
sent to anybody other
Fragments
than
of her
the
tail light are at
evidence?
the
Were they ever
scene
removed
near the
and
dead
used
body.
lab personnel.
That gives you some proximity of, okay, you may have been there, right?
Yes, I did.
Inside that bag.
It's telling
is-
me a
Yeah,
little
well, they
story.
weren't able to
Pieces, or
find
was
any
there another
pieces during
piece
their
in that
first
bag?
or second search. It was only during
another
subsequent
piece
searches
in
they
the
found
When you
pieces,
put
which is
the taillight pieces
suspicious.
in that bag,
And then,
how many pieces did you
like,
put in
pieces
the
just
bag?
pop up.
I put 2.
It's like it was
Do you know
0,
if
then it
the
was
other
0,
piece
then
in
it
the
was
bag
like
is
4,
piece that
then it
broke
was
off?
8.
You know how that arrived there?
It just kept
I do
like
not.
changing
Can you just pull out
constantly.
that other
Well,
small piece
I
and
do
show the jury
know
as well?
evidence collection in the snow is very, very difficult, especially if it snows right after the event or if it was snowing during the event, because the snow does cover quickly stuff. So things that you would expect to see sometimes you won't find until days after. Because
But they didn't find
you know,
any, Nate. They
Yeah.
didn't
No,
find
but I'm saying
one.
sometimes. I'm just saying if this happened during a snowstorm or was it after a snowstorm or
smaller
was it snowing
piece
outside?
consistent with
Because
the same color as the
that
two
does
bigger
affect
pieces?
it a lot.
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please.
Not saying there's no funny business going on here, but I'm just saying I've just had that situation happen. Like, oh shit, it's still snowing.
Okay.
You just can't get everything. Sometimes they try to scoop up all the fucking snow, but then
Yeah.
you lose placement on where things were found, and you got to do it gets
Ooh,
really
that's a nice bright laptop. Whoever has that bright red there, man. Damn. Bright red, blood red laptop in the courtroom. Damn. That's a look.
But I'm assuming the defense is going to definitely, about this.
Yeah.
Destroy.
Yeah,
this
but
whole-
yeah, they found 0 parts during the first or second searches, and then like also the homeowners never found a single part, even as they are presumably going to and from their house literally every single day. They never found any parts.
Nah.
And then like at one time the police just like, let's just drive by, just randomly on our way to work. Let's just pop by. Oh, we found 20 pieces. Oh, what a weird coincidence. It's like the things are just
Yeah, that
very
doesn't sound
things are
right.
very sus.
That doesn't sound right. I know, like for instance, for the OJ situation, OJ went during the OJ trial. Most people don't know this, but after they did evidence collection, they went back. I think maybe a week or a couple of days later, and looked at one of the gates, the external gates, and saw a bloody thumbprint on the gate. They got it, matched it to OJ, and wanted to present it at trial, but
it to you in the witness how
they couldn't because it was too late. They were like, it's just there's no. You were there for 2 weeks. You couldn't find it. Now all of a sudden you find it. It just
Sir,
just
on the
wasn't
small
reliable.
Yeah, it's a little
chip,
sus.
You don't know
Yeah.
how it became
So OJ's bloody fingerprint
not.
was found
After
at the
you remove
scene,
that
but
chip,
you can't use it.
like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
And then I'd like to introduce that exhibit.
What is
What
this?
is-
Like the smallest piece of taillight fragment ever?
So we're going to mark the little chip.
Really?
You want-
Mr.
you'd like to mark
Yannetti
it?
asked to
Okay.
mark that.
Marking as
And we're going to
exhibit.
submit that for identification. So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope for that.
Thank you very much.
Yeah, so it's not in evidence as of yet.
Thank you.
The little chip. The little chip gets its own number. How nice.
If
It's its big day.
If it's multiple things, yeah, there's something the last one in there. And I'm assuming that the little chip, they may be making a point
But we have
about
one
the chip.
more bag of items to go through.
Yes.
One more bag. So this is just
Could I
the
have
evidence
exhibit
collection guy.
73, please. Sir, if you could look at exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you a photo. Do you recognize what's in it?
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Fair and accurate. Yep.
This is evidence as an exhibit, please.
Okay. There's no
Now
objection, Mr. Yannetti?
let's get the bag.
Exhibit 79.
With the court's permission, could we show exhibit 79 to the jury?
Yes.
Let's get the bag.
Ms. Gilman, would you be able to close? Thank you.
Turn off the lights. I'll show you where it was
You
at.
recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please?
They didn't go through the whole, is your name on the bag? Did you sign this? Is this your signature? They didn't go through all that process, but maybe they
Are
probably
these
like,
different in color than the last pieces
we're going to
you
skip
showed?
all that.
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Yeah, I've forgotten about that cricket. Last time at the last trial, when they opened up the bag, there was more things in the bag than the bag said there was in the bag. Was nice. Yeah, the bag. It's like, oh, there's an extra piece in here. Oh, that's nice.
So these are more pieces of the.
The pieces are multiplying.
Thank you, trooper. I've
We go
moved these
back.
items to evidence.
Move them to evidence. All right. So now they're evidence. Before they were just exhibits. Now they've moved them into evidence. No objection.
Thank you.
And now we get to hear
Thank
what's
you,
wrong with
Keefe.
the evidence.
Thank you, sir.
Here it
All right,
is.
any questions, Mr. Yannetti?
Of course. Unetti has questions.
Of course he does.
if they gotta
when were
be-
these pieces? When were these pieces discovered?
There it is. That's what I'm listening
Good morning,
for
sir.
now.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Kerry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement.
What do you think
to-
it is? Take a guess.
With the owner's consent, we are able to conduct an extraction of the device.
Yeah.
Okay. And on that consent form,
Is that a right? Is that a
there
proper answer in
is
court?
a
Take a
description
guess.
of the item itself.
Can I say that?
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form,
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well?
That's correct.
I'd have been going to my partner, like, where is he going with this?
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022?
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Refresh my
So,
recollection.
your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
Refresh your
Mayor Pro Tem?
recollection.
Yes.
There it is. Now you can't read the form because that would be hearsay. He can just
Right.
refresh his recollection and then say, "Okay, now I remember."
Read that silently and then look up at me when you're done, Trooper.
You see that? That's why you got to read it silently. That would be hearsay if he starts reading it out loud.
Yeah,
Having
well,
reviewed
doesn't
that
stop them
form,
in
does
some of
that
these
refresh your
exhibits,
memory
but you
as to
know.
whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct. 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the,
I will not.
Exhibit 89.
That's because it's subject to redaction. have to redact anything.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
That's the name.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation, no.
You have not yet.
No.
Well, there might be a job
The
opening.
lead investigator is the trooper who is responsible for the case, correct?
Yes.
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
Yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes.
The two of you have worked cases together in the past, correct?
A few.
You've worked on this case with Michael Proctor, correct?
Yes.
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
You'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
Looks like they've got some inconsistency here. He's got to go look up. I don't recall that he didn't expect that answer. That's why I was looking through the paperwork. You're like, oh no, you're supposed to say something else. When I was talking to the prosecutors. No, that's Karen Reed's. Yeah, the prosecutors.
I'm gonna get a skin for my laptop. I want orange skin for my laptop.
On October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes.
Okay. If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach you, Honor?
Yeah. So the answer was wrong. He depends on this answer to move forward. So now he's got to refresh it to get the right answer. And it's actually good if he can get this guy to admit that the first answer was incorrect, because then it throws into question everything he said on, it throws into question his credibility, which is what you want to do if you're the defendant, right? If you're the defense attorney, you want to make sure this guy's, I don't know what's right. I don't know what's wrong. I don't know that's what you want. My memory is not as great as I thought it was going to be. But why is this point so important, though?
I don't know. The defense does have a tendency sometimes of chasing after stuff that doesn't really matter.
Yeah.
Yesterday, they chased the difference between, what was it? They like,
I placed a
God, I can't remember. It was like the difference between
yourself. Look up at me when you're done.
something like they were satisfied versus very satisfied, something like that. You know, it's like just an extra adjective, and they chased that difference down. And like the guy said, "Oh yeah, we were satisfied." Don't you mean very satisfied? Isn't what we testified to before? I'm like, really? Are we chasing that down seriously?
Satisfied versus very satisfied.
Yeah.
And the only problem with that is that if you make something seem too important, but it's really BS, then you lose credibility with the jury.
Yeah.
So sometimes you gotta let just minor stuff go. You know what I'm saying?
That's what I've been trying to tell. That's what I've been trying to tell people, especially with like those early witnesses in Jackson, like chasing the EMTs and the firefighters off stuff was like burning way more energy. It came off to me as arrogant, hostile, aggressive, bullying. It was not working for me. Chat was fighting me. They thought it was great. I'm like, no, I don't think so.
Yeah,
Chad and I disagreeing has been known to happen.
That's true. But it really depends on how the jury takes it, though. And just because you're saying similar disagreement, if the jury can take it one way, she's versus another way, so you just don't know. That'd have been a good time for a poll. Just poll the chat.
What are we polling?
No, I'm talking about when you had that disagreement to give a poll to say. Because if the poll was 50-50, then you can tell
Just
that
so we're
it's
clear,
issue.
I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh. Take a
Sure,
look, sir.
go ahead.
Just so again we're clear, you can't read anything anybody said or even anything in the document because it would be hearsay, except unless it falls under a hearsay exception, because they're possible if you're not presenting it for the truth of the matter asserted. So, but they are presenting this for the truth of the matter asserted, so he can only refresh. He can't speak it. You guys are getting some evidence. Get evidence out.
Yeah, evidentiary basics. Evidentiary
Yeah.
basics with Professor Nate.
Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson
gotta say yes.
with Michael Proctor on October 21st of 2022?
Say it. Say yes.
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes,
Okay.
I messed up before.
And the two of you would have participated in that interview together, correct?
yes,
But you did not write the report, correct?
no, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the
Which
language.
would be even more basis for him to say it doesn't refresh his memory, because anything can be used to refresh your memory.
Yeah.
But if he didn't write the report, there's no particular reason that it would refresh his memory. It's like, I didn't write this.
But
So
to refresh his recollection was about whether he was there in the room. Remember, he said he wasn't there, and then they refreshed it and said, "No, here's the report. It says you were there." Now he says, "Yes, I was there." So that was the point for refresh.
Fair enough.
Language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. Let me approach Judge.
Yes.
So this is their Mark Furman. Proctor is their Mark Furman.
Proctor is
Okay.
definitely their Furman. Yeah, 100%. Yeah. Arguably
Other
worse.
examples are the reports on
He's
the
pretty bad.
videos that you well, strike that. Let me start by saying this. Asking you this. You retrieved videos from both the Waterfall Bar and Grill and C.F. McCarthy's, did you not?
That's correct.
Yeah, we'll do a poll on that.
You and Sergeant Buchanan
Can I even do a
retrieved
poll?
the videos from C.F. McCarthy's, correct?
Yes,
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Yeah.
Sure.
Thank you for the 400 of you currently tuning in, by the way. Don't forget to hit the like button. And don't forget to hit the retweet at 550 likes or 75 retweets. We're going to do a merch giveaway. It's going to be fun. I'd recommend getting some fan merch, personally. but it's up to you. We have Spinny fan merch now, Nate. It's great. Yeah, Spinny fan merch.
And again, if you read that silently to yourself and look up at me when you're done.
We're working on a Brady Bunch style, like mug, where they're going to be different fans from different courtrooms.
Oh.
That'd be fun. And we're going like the only fans, right? We're going to do an OnlyFans kind of thing, a motif. It's going to be good.
That's a good idea.
Yep. Patent pending. Do we ship to Scotland? My understanding is we ship to the EU.
To avoid the tariff?
And the UK. So I think the answer is yes, but I can't guarantee it. Maybe. We apparently ship to UK, EU, Canada, Mexico, Australia, and Japan. I don't know that for sure, but that's tentatively what we've got. So hopefully. If not, then I don't know. We'll figure out something.
Tariffs.
Tariffs too, yeah. You're definitely responsible for tariffs. I'm not covering that. I'll cover shipping. Tariffs are on your end.
Reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Are people still not happy with the audio levels in chat?
I said
I've already
waterfall.
adjusted it 3 times. What more do you guys want in terms of audio?
This is C.F. McCarthy's.
Okay, I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes, again, I
See,
only
I can't
got
hear
a
it,
copy of the
so
surveillance
I need
video.
people to tell me.
I did not do any
It's
analysis.
just very,
with
very
regard to
annoying
the
browser-based
waterfall bar
streaming.
and grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
Now, another member of your unit was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
You want the feed louder? Fine. I'll set it to 130%.
They're going to argue over the nickname. And the reason why it's going to be arguing over the nickname is for a simple factor: relevance. Is it relevant to this particular case? Now, I don't know what the nickname is, but that's probably the objection. Relevance.
Yeah, could be fun.
Yeah. Maybe his nickname was the false arrester or something like that. I don't know what his nickname could be. But whatever it is, they want it in.
Yeah, I bet they do.
Now, just for everybody knows, relevance is a very low bar. It's just, does it tend to make a fact more or less likely? So, let's see.
Proctor is apparently winning the poll at 84%. People think Proctor is worse. I'm not surprised. Proctor sucks.
All right. Here we go.
Trooper, in terms of the troopers that were in your unit as of
They got denied.
29th
Can't
of
ask that.
2022,
You'll never know.
which members of the unit had the least amount of time in the unit at that time?
Hold on. Let me. I'll be right back.
I don't
right.
recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes.
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You
That's fair.
attended the autopsy of
More time
John
isn't
Keefe on
necessarily more
January
experience.
31st
That's fair.
of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
The medical examiner's office in Sandwich, Massachusetts.
In Sandwich, Mass. And
Sandwich.
it was Dr. Irene Scorti-Bello. who
That's where the
performed
shit
the
started.
autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Sustained, you can ask that differently.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay.
I bet you would.
I may have a moment.
The exact words are going to definitely help you, I'm sure. There's nothing in that report that's going to save you, my friend.
May I approach, Your Honor?
You want this one back?
Oh, please, thank you. So I've placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done. And I would direct your attention to the second page for the question I just asked you. Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of...
I mean, if it was his first autopsy, I think he'd remember. So I'm pretty sure he can remember what his first autopsy is. Yeah, it seems like the kind of thing that would stick with you a little while. I don't know.
The CPAC unit or the Norfolk Detectives unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Objection.
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of questioning.
Sustained.
May we approach?
Okay? Jurors, feel free to stand up.
Yeah, the question is slightly odd because he can't really speak to what they saw, like what the medical examiner saw, because yeah, he wouldn't know. he could say what the medical examiner did, like if he saw the medical examiner like touching things or like, you know, examining things, but what he actually saw is the question is slightly malformed. So I think, yeah, I think the is a proper objection. It's like, yeah, I was there witnessing it, but I can't really say what he saw or didn't see. You know, I can say he was looking vaguely at something, but what he saw, you know, that's more subjective, you know, in the mind. So the question is slightly malformed. I'll give the state the point. Better would be like, did you see like the medical examiner take measurements of the wounds on the arm? Did you see them take photographs of things, or you know, more concrete related actions? You know, but I mean, I assume that you guys have been looking directly at something, but not necessarily seen it. I know I know it's happened to me before. I know it's probably happened to you too. Like you've been looking right at something, but you can't see it. Especially if you happen to be looking for it at the time. Probably happened to us all, right? I'm looking specifically for something. I'm looking right at it, but I can't see it. Yeah, it happens to us all. Perception is a bitch. And then, of course, what conclusions the medical examiner drew would be hearsay at that point, because it'd be what he heard, and we're offering it for that truth. So it's a hearsay problem. Unless we can then say what he did on the basis of that, and then it goes to the effect of the listener, but that question wasn't asked.
Were you watching Dr. Scorti-Bello as she was conducting the autopsy?
Now this is better.
Yes.
Did she appear to be looking at John O'Keefe's body?
That's
What direction were her eyes facing when she was examining John O'Keefe's body?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And in order to do that,
the body.
I'm sorry?
She was looking at the body, I assume.
Thank
I'm not
you.
in.
Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
there you go. Go to what he saw. There you go.
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she
Why would
examined
he?
the body, correct?
We don't give input. We give the facts that we know so far in the case.
Which is input,
Well,
incidentally, by the
giving
way.
the facts is giving input, is it not?
Yes.
It's not input.
Yes, it is. It literally is.
Okay. Did you talk to Dr. Scorti-Bello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
There you go.
And
Rephrase.
at the end
Good
of
job.
it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
Anything, Mr. Carter?
No, none, thank you.
All right, you're all set, Trooper.
Thank you.
I think the better way to ask that would have been, was there a determination as the cause of death when you left? Because that, like, without revealing what it was, I think that would have been allowable, but okay.
So, jurors, this break we're going to take now,
Are we on break? Is it break time? Is it time for stretches?
all right, we're going to take a break. The lawyers and I have some work that we have to do. So
I bet we do. I bet we have some work to
longer
do.
break than we normally take, and it's a little bit earlier, but we did get coffee for you. So,
Ooh, the jury gets coffee. Do they get donuts? And some crullers, maybe? Maybe a Danish? What kind of Danish do you think they get?
Close your notebook, follow me.
All right, there's going to be a hearing. I presume it's relating to Proctor or something. Bev is condescending? Yeah, she is a little something, yeah. Condescending is one word for it. We'll go with that. I want, yeah, like a raspberry donut, Danish or something like that would be good. If it's fresh Danish, you know. If it's stale Danish, you know, not so much. Split Finny, yeah, absolutely put Spinny fans in the chat. 100%. Well, wait, sorry. Never mind. Sorry. 1 second, please. Talk amongst yourselves.
I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate...
One's a Massachusetts case, so that's easy enough.
Okay, so, and that's a shall...
It's an SJC case, so yes.
Yes, okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course a court is a judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor.
I mean, sure, why not?
May I approach?
Yes.
And then what relevance it has to this case, who knows? But sure, why not?
CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. In the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case what was presented, her report, because it was deemed not reliable. And that is what...
In one area, right? One specific area?
Well, you can call it one...
The decision.
Right. Oh, yeah, just what's in the decision, but there's two parts to that decision, two areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes, that she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your
Well,
Honor.
one person
But
does.
is it that, so you want to put in
Nobody in the country has the Apple source code. I can think of at least one person who has the Apple source code.
her report and question her about a proceeding in Maryland? I need to know exactly what you're asking
If I could
me
proceed
to allow.
with the answer, Your Honor, I will
ahead.
explain it. It's a very short answer.
Okay.
What I want to do is, with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp, she is not using Apple's source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is, in fact, what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she...
All right, so let me see if I understand the issue in my own head. All right, so we have a witness who did something relating to an Apple product. I'm 100% clear what she did, but she did something in Maryland, and a Maryland court was like, nah, we don't think that that's reliable. Which, okay, fair enough. I mean, it's an evidentiary issue, and some judge somewhere made a decision about that. And he wants to use that Maryland decision to impeach her testimony or say, wasn't this found to be unreliable by Maryland in a Massachusetts state level proceeding? Okay, for its legal value, I certainly understand how it might be legally relevant to me as a judge, but just because that judge ruled a particular way doesn't mean I have to. I mean, judges disagree. It's one of the things we do with our time. We disagree with each other for sport. So, could I look at the exact same information and come to a different conclusion? Maybe, because judges do it all the time. So it's like, if you want me to take judicial notice of it for the purpose of potentially influencing my legal determination, fine. If I come to an independent legal determination and I'm like, no, I'm going to allow that, can you then use the fact the Maryland court was like, no, and attack the witness on that basis during her testimony? I don't know whether or not you can do that or not. That's a very interesting deep dive evidentiary question. I don't know. I don't know whether you can do that.
Is not asked about that, then what?
Didn't Bev say it was a Supreme decision? We're talking about two different decisions. So yeah, there was a Supreme Judicial Court decision, which relating to something, whatever. And she said, yeah, obviously. And now we've moved on. We're on to decision number 2 out of Maryland that we want to use this decision. And incidentally, even if it was from the Supreme Court of Maryland, it still wouldn't matter because I'm not in Maryland. So whether it was a trial level decision or the Supreme Court of Maryland, it still wouldn't necessarily impact me. The Supreme Court of Maryland can come to a decision. I can come to a decision. We might disagree. So yeah, I don't know. I don't know whether or not you can do that. That's some deep dive evidentiary things, because it's not like, yeah, I don't know whether or not you can do that or not.
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in the Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis in that opinion. That opinion
I don't see
did not
it.
say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code.
And the other court's decision relating to Daubert doesn't necessarily impact me. I mean, Daubert is obviously a Supreme Court case in the end, so hypothetically, but different states are going to look at things differently. So just because another judge said no under Daubert doesn't bind me any more than another judge said yes under Daubert. Right? I mean, because that obviously swings both ways. Just because a different judge said it was okay for them, maybe that judge just has loose standards. Maybe the judge just allows everything in the door, and they're just like, no, I'm going to take a harder look at it. Or maybe the judge just is overly strict. So for its value in potentially influencing me as a judge as to the legal determination, sure. As to, because that court found it was not admissible, therefore I should be allowed to question you, the witness, about it. Yeah, I'm not seeing it. I'm not seeing it. Yeah, I think the basis. Yeah, I think the basis to use as a question. I'm not seeing it. Defense motion denied. I don't. Yeah, I'm not buying it.
It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court.
And even if it had been, it wouldn't be binding on me. That's the problem.
Part of this opinion whatsoever. And so because another court didn't allow something under a Daubert.
Yeah, I'm not buying it. I'm not buying it.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp.
No, that was raised, but this.
I'm not buying. I'm not buying it.
The same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor.
Okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the State Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph.
No.
It says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on.
You can absolutely cross her as to her reliability. You just can't use the determination of the court to do it. So you can use the same factors that court used. You could use the same underlying information. Like, isn't it true that you didn't have the source code? And isn't that, like, you could use the same information. You just can't use the conclusion. That's the thing you can't do. This is a no for me. I'm not buying this argument, Alessi.
The reliability of their methodology. And lastly, with regard to the Apple source code, If Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross.
I mean, you can ask that question. You can ask it, isn't it true that you didn't have access to the source code? Isn't it true that that is a black box? You can ask the question, but you could have asked that question anyway, right? So, but what you want to do is you want to use this opinion coming out of this other court and be like, yeah, no, I'm not buying this. I'm not, yeah. And then you want to ask them, isn't it true that some judge somewhere made that? No, that was a legal determination by that judge. So I'm not buying it.
So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got dollarized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them in this case. It's just basic cross-examination.
You can't ask that ultimate question.
To dehumanize somebody, daubertized, to use a term to suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue.
Yeah.
By their analysis, if an expert goes into court on a motion on anything to do with data forensics and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic.
Yeah, I'm not buying it.
At another case, they have not shown any evidence that this issue has anything to do with her effort.
I'm not even 100% sure that even if that case had come before the Supreme Judicial Court of the same state, it would necessarily be applicable because every case obviously turns on its own facts. So even if you had a decision from the Supreme Judicial Court of Massachusetts on this point, obviously I'm bound by the legal determination of the court, obviously, because it's my superior court. So their legal determinations are binding, but depending on exactly what they wrote, what does that mean for me as the trial judge is not necessarily readily apparent. So I'd actually have to read the decision and see exactly what the Supreme Court was saying and not, right? So it's like you might be able to distinguish even if it was the same state, let alone a foreign state. I'm not buying any of this bullshit. 499 from Christopher Mays. If an expert has opinions stricken as unreliable, that speaks to credibility and is usually admissible. That doesn't seem right to my head because if that were true, then the opposite would seem to be true, and that doesn't seem right. So if the expert had deemed to be reliable by the other court, so the other court had a hearing and they did their thing and they said, yes, we find it to be reliable. And you came in and said, well, because that court found it reliable, you're required to find it reliable. Like, yeah, just like, let's work this through, right? Let's work this through. Suppose the other court had said, okay, here's some data forensic stuff. In my case, whatever it is, there's some data forensics, and you can make it as one-to-one as you want to be. Like we can make it as one-to-one on point as you want to be to make this work. We'll just assume that it's one-to-one so that we don't have to get into how analogous it is. We'll just assume it's one-to-one, okay? So let's assume this exact same issue somehow percolated in a Maryland court. Okay. And the Maryland court is doing its thing and does its hearing. And they're like, yeah, no, that's sufficiently reliable. You know, it passes the Doe-Bear standard. You know, I'm okay with that, goes forward. And we'll do you even one better. Let's suppose that decision then goes on to the Supreme Court of Maryland. And the Maryland court, the Supreme Court of Maryland eventually says, you know what? We've looked at it and we think it was sufficiently reliable, affirmed. Okay. Now you come to me and I'm in Massachusetts and you say, look, this is a one-to-one case, Your Honor. This is one-to-one. The trial court in Maryland said this was reliable. The Supreme Court of Maryland said it was reliable. Therefore, you're required to say it's reliable. We want to ask the question. We want to ask the question, isn't it true that you were found by the court in Maryland to be reliable and trustworthy and all those things? Isn't it true that you're found by this other court to be reliable and trustworthy and believable and all the things? And I'd be like, no, that's some bullshit. Because the Supreme Court of Maryland has its head up its ass. I'm Massachusetts. They're the Supreme Court of Maryland. They're their head up their ass. I don't know what they were doing. I'm not going to do this at all. I'm not going to even allow the witness to testify. I'm going to do my own Doe-Bear hearing, and as I do, and I'm like, no, I don't know what the Supreme Court of Maryland was doing. They have their head up their ass. I'm not even going to allow the witness to testify if they're so unreliable. You're required to allow them to testify. The Supreme Court of Maryland said they're reliable. Who are you? I'm like, well, I'm a judge in Massachusetts. Go fuck yourself, right? So they're on the stand and I'd like to, confirm how reliable they are, ask the question about how reliable they are. That's buttressing. Go fuck yourself. You can't ask that question, right? So if you can't do that, you can't do the reverse, right? Because the rule needs to swing both ways, right? So if it doesn't work one way, it doesn't work the other way. So if, flip literally everything on its head, the Maryland court had said no, the Supreme Court of Maryland said no. And I'm like, I don't know what the Supreme Court of Maryland was on. They have their head up their ass. This is clearly admissible. Fuck you. And so I'm going to allow it. And now you want to impeach them based on a decision of a foreign court? Get fucked. Get fucked. Now you can ask the question about the same basis. You can ask the question about isn't it true that you didn't have the source code? Isn't it true that, that somehow you can ask all those questions. You can ask all the questions that would lead to the conclusion it's unreliable. You just can't ask that last question. Isn't it true the Supreme Court of Maryland said that you're a bunch of liars? Fuck you, man. Right? So I'm not buying it. I'm not buying it, counselor. It's not working for me. Yeah, I'm not buying it. It's not. I'm not seeing it. I'm not buying this analysis. Yeah.
In the timestamp, they just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected?
And if you don't think there's a state judge out there who would love to tell the Supreme Court, not only of their own state, mind you, which they would want to do that too if they could, but that wouldn't want to tell the Supreme Court of a different state to go fuck themselves, man, you haven't met enough trial judges, man. It's just yeah. I definitely want to tell the Supreme Court of another state to go fuck themselves. That sounds like fun. I like to tell it to my own state too, but I can't get away with it. So, what can I do?
By any court. What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to how data steps. So there are certainly aspects directly relevant. Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness on which she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? That one of the fundamental ways you do it is, and I don't mean to dehumanize her, I won't even use the term Galbraitize anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability.
I mean, if you want a Doe-Bear hearing in this case, I assume that you could have done that and used this as a basis for a Doe-Bear hearing. Either you didn't ask for one or your Doe-Bear hearing was denied by this judge. Different judge looked at it differently and came to a different conclusion. Doesn't necessarily mean that mean it either was wrong, because there's also a discretionary analysis in this. So they could simultaneously both be right. But yeah, I mean, just because the other judge said no under Doe-Bear, you want that to bind me? I don't think so. And you want to ask the question to this witness about what another judge ruled under a Doe-Bear hearing, which itself is a legal opinion? I don't think so. I'm not buying this, Alessi. I'm not seeing it. Myra for 20 or 50 SEK says, thanks for your coverage. You're welcome. And thank you to Meme Copium, by the way, for the nice raid. It is appreciated.
So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, and any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let
This is completely not working for me. This is totally not working. This would be like saying, because the other judge in the other state found this person to meet the Doe-Bear standard, I am as a judge am therefore also required to say this meets the Doe-Bear standard. That's insanity. That's insanity. That would mean that the very first judge who ruled on it would bind all judges everywhere, and no judge could possibly disagree. That's insanity. It would also mean that, like, if this expert has suppose the expert's testified in 20 courts in 20 states, and I'm the 21st state, and I take a look at it and I'm like, I don't know what these other 20 states were on. They all have their heads up their ass collectively. I don't know what they're on. I'm going to disqualify that witness. You say I can't do that? Bullshit. Yeah, you say I can't. You say I have to. I have to. Like, I don't think so. The opinions of 20 other states and 20 other judges and 20 other Supreme Courts, for that matter, will be very influential, I'm sure, as I'm rendering my opinion. But in the end, if I, in my best judgment, say like, no, I have to be able to say that. And so it must be true the other way too. It must, if it's true one way, it has to be true the other way. It seems to me. So I'm not buying this.
Point on redirect, but I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on.
Yeah, no, Christopher, no, I understand whether it's been accepted by other courts as a consideration of Doe-Bear. No, I get that, but it's a legal determination. Yeah, no, it's totally relevant to me as a court as to whether or not I should qualify this person under Doe-Bear. No, I get that. Now, we're not denying that. The conclusions of these other judges is going to be super relevant to me in my determination. If 20 other judges in 20 states have said, no, we're not qualifying this expert, and I'm the 21st state, and I'm looking at 20 opinions from 20 states that say no. And I'm like, should I qualify this expert or not? That's probably going to be pretty influential on my analysis, but it's not dispositive. That's the difference. And if somehow, some way I say no, I say, you know what? Yes, I'm going to allow it. That therefore I have to let you use those opinions in your cross. Like, no, for the exact same reason the other way around. It just doesn't make sense to me. It doesn't make sense. Maybe I'm off my rocker. Maybe I'm off my rocker for allowing this person to testify. Or maybe somehow I've reached the right conclusion despite, my contemporaries all coming to the wrong conclusion. But either way, it's like, yeah, I'm not seeing how you can use the opinions of these other states to cross-examine, because you can't use the opinions of the other states saying you were reliable to buttress. If you can't use it to buttress, you can't use it to cross-examine. It doesn't make sense. Yeah. As to the questioning on the stand, I don't get it. Yeah.
Anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the...
Of course, it is quite possible that I'm missing something here, to be fair, because criminal law isn't necessarily my favorite thing in the world anyway. So it is quite possible I'm missing some nuance here under law. So if there's another lawyer out there who disagrees with me, I'd be interested to hear their analysis. Maybe they could convince me I'm wrong, because it's not necessarily, this is a very interesting issue. I think I understand the issue, but it's possible I'm missing something. So if Uncivil has his head up his ass a little bit on this one, Uncivil apologizes. But Uncivil can't see it right now. Although it might be because he has his head up his ass, but you know, I'm limited by my own abilities. What can you do?
Location,
Yeah,
she has in her
yeah,
power.
we need Nate. Yeah, Nate was a criminal lawyer. He was a prosecutor, so Nate might have a better idea on this point. Yeah, that's quite possible. I need someone who's a criminal specialist, expert witness specialist would be nice, who can walk me through whether or not this makes sense.
Point she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert, and this is how they're going to distort it. Invoking the Constitution, and invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point.
And even then,
This
I'm
has
not sure.
Nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. He just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate decision.
It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it overturned on appeal, then this would be a different matter. But this is the
Bullshit.
This is a
Bullshit. There's no possible way that's true, even in the same state. That can't possibly be true. Even if I were in the exact same state, if I were a Maryland judge, because this judge, when they did Doe Bears, like no, therefore I also have to say no. Bullshit. There's no possible way that's true. Since when are trial judges binding on other trial judges, let alone themselves, man? Come on.
valid case, and even if it wasn't, it shall be in evidence. So there's two issues here, and I think the
Three other channels thinks the lessee is 100% correct. I need to talk to three other channels, man. I'll tell you what, man. Yeah, it is possible I have my head up my ass, and I'm not understanding something. I need to talk to three other channels because I'm willing to be convinced I'm wrong on this point, but it just doesn't make sense in my head. Yeah, I'm willing to be convinced I'm wrong, but someone needs to convince me. I don't have a firm enough opinion. It just doesn't sound right to me. Yeah, I have questions.
Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence?
Also, incidentally, by the way, it wouldn't be the first time that even judges disagree with each other, as I pointed out, right? Sometimes Supreme Court judges disagree with each other. Sometimes they're 8-1 opinions. So, just because even it's not necessarily the case that if I walked it all the way through with all these other lawyers that we'd necessarily even agree in the end. Sometimes the Supreme Court can't even agree with itself. So, there's sometimes differences of view. It happens. What can you do? It's law. It's fun.
To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology with regard to her PowerPoint. You heard Mr. Brennan's answer. He is going to include, he has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have my cross-examination struck before I even get to pursue that with the witness. And I believe once I pursue it with the witness, it will become evidently clear that it's a proper basis for cross-examination.
Right, and Mr. Lessie, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Presumably, you would be under the state rules.
Your Honor, my answer is I would be entitled, but I would say this. If they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user.
Alessi's arguments are really good arguments as to why this expert should not be allowed under Daubert, or why the judge should limit these are good arguments as to why the judge should limit the scope of the testimony or exclude the witness. They're really good arguments for a Daubert argument, but Daubert is a legal argument. So if your argument is I should reconsider this witness's testifying or what they can testify to or the scope of their testimony under Daubert, these are really good arguments. If your argument is I should be allowed to present the conclusion of this other court as a cross-examination question, the conclusion of the other court as a cross-examination question, no. My answer is no.
The same with the second part of the phone calls, but if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that
great question, though.
A defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence. But not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence,
No.
which is a key issue of
No.
crossing an expert. Her
No.
competence.
You can ask her every question in the world relating to her competence, her ability to draw conclusions. You just can't use the ultimate conclusion. But that's what you want to do. I have no problem you questioning her and her ability to reach her conclusions, the fact that she didn't have Apple data, what that would mean. You can ask her all those questions. You just can't ask the "isn't it true" the court in Maryland. You just can't ask that question. But you really want to ask that question. That's the question. That's the line. You can't ask that question. No, I'm not. No, you can't do it. Sorry, not happening. Uncivil says no. We need the court of law tube. We need to appeal to the court of law tube so we can see what we see if court Uncivil's wrong.
Evidence has been determined in this decision, and it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue. Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's...
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue, and they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly. But
Fair
we'll
enough.
see. She's
Fair
here?
enough.
Your Honor, may I ask one thing? May I, Mr. Brennan?
Yeah, if you're gonna.
I just want to know, is she here?
She is, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
Yeah, I mean, I don't. Yeah, this is a very interesting legal issue. Okay, yeah, we're on break, I think, for some period of time. I need another lawyer to walk me through this, I think. Yeah. Yeah, I need another lawyer to walk me through this. I don't know. Yeah. It doesn't seem right, though. It doesn't seem right because if I can't ask the question buttressing, if I can't ask the buttressing question, which I don't think I can, then I can't ask the undermining question because it would have to come. It seems like it has to come in a pair. You know, it would seem like wildly objectionable if the lawyer said, "Well, isn't it true that you've testified in this trial and you were found to be reliable?" Of course. Isn't it true that you were testifying in this trial and found to be reliable? You better believe it. Isn't it true that you testify in this trial? You're found to be reliable. Of course. So, you know, it's improper buttressing. So if you can't do it the one way, I don't really think you can do it the other way. If the question is, isn't it true that you've been like certified in other courts or is it true that have you ever not been certified by a court? Then yeah, you probably can ask that question, but the more specific question, I'm not sure. I'm not sure if I buy that. Not for at least the reasons that some judge somewhere might just have their head completely up their ass. And it can't possibly be true that I'm stuck with that. Right? It can't possibly be true that some rogue court, including some rogue Supreme Court, it can't be possible that some rogue Supreme Court is necessarily impeding themselves in my trial because they had a bug up their ass. Yeah, that just doesn't sound right. Yeah, that doesn't sound right. I don't. I think this is a no for me. Yeah. If the earlier opinion was not about her, I'd agree 100%. Well, what if it was about her? Yeah, so we can make it 1-to-1, Chris. That's fine. Same expert, and let's make it 1-to-1, which is a very weird scenario to be in. But let's reduce our complexity, right? So same exact expert, same exact issue. It's 1-to-1. The other trial judge said, "This is fine. It meets Daubert. This is the most reliable testimony we've ever seen in our lives. It's the greatest testimony, the most reliable testimony. I can't believe you'd even raise a Daubert motion. This is the bestest testimony forever and ever." And the Supreme Court of what's a good fictional state here? The Supreme Court of Wilson. So the trial court of Wilson said this is the greatest thing ever. The state Supreme Court of Wilson said it was great testimony. And now you want to ask this person, isn't it true that the Supreme Court of Wilson said that your testimony was the bestest ever? Yeah, 9 justices of the Supreme Court of Wilson said I'm the bestest, sharpest, most wonderful witness ever. Right? 1-to-1, same witness, same issue. I feel like there's no way that question's proper, right? I'm not out of my mind, right? That question can't possibly be proper, right? I mean, if it's not proper the one way, can it be proper the other way? Right? I think asking the expert if a given test has been adopted as reliable is okay. Yeah. It's been deemed reliable. But like the specific has your testing been found to be reliable? I don't know. Yeah, so the Supreme Court on a 1-to-1 issue with the exact same expert, and a 1-to-1 issue, the Supreme Court of Wilson says this is the bestest we've ever seen. Totes wonderful, greatest ever. The Supreme Court of I don't know, the Supreme Court of Kennedy. The Supreme Court of the state of Kennedy says this is garbage fuel. We don't know what the hell is going on. So now I have an opinion from the Supreme Court of Wilson and the Supreme Court of Kennedy. One saying this is the greatest ever. One saying it's garbage fuel. What can I? And you asked me to take judicial notice of both these decisions. I'm like, okay, I'll take judicial notice of both of them. You asked me to make a Daubert decision. I make a Daubert decision. We're going to assume it's allowable. Otherwise, this conversation doesn't make any sense. And now I'm like, yep, it's fine. Daubert, it meets Daubert, no problem. And so now the person offering the witness wants to say, well, isn't it true the Supreme Court of Wilson said you're the greatest? And the person crossing says, isn't it true the Supreme Court of Kennedy said that you suck balls? I'm not sure either of those questions is admissible. Yeah, that's my problem. Or Fry, either way. Daubert or Fry, take your pick. If you think it's Fry, just substitute Fry for Doe-Bear in this sentence. And just, yeah, we're all Doe-Bear states, or we're all Fry states, or we're all whatever. We're all equal on the Doe-Bear Fry. Like we don't have a difference on this point. We're all equal in our application of Doe-Bear / Fry. We all agree as to that much. So we don't have to worry about that issue. Right? Well, yeah. So the Supreme Court of Wilson says it's great. The Supreme Court of Kennedy says it sucks balls. So now we're in the Supreme Court. Now we're in the trial court of uncivil, the state of uncivil. We're in the trial court of uncivil, and the judge has said, yeah, this is allowable. And the person offering the witness wants to say, the Supreme Court of Wilson says this is totes awesome. Isn't it true how great you are? And the person on cross says, isn't it true the state of Kennedy says that you suck balls and everything you says is garbage fuel? Are these questions admissible? Is one of them admissible and the other not? How does that work? Yeah, that's my question. Also, I'm thrilled to announce that we now have 53 states in the union, because I just created some states in this hypothetical. So we now have 53 states. That was fun. We admitted some states along the way. That was good. Yeah. Yeah, there's 3 different opinions from 3 different law tubers. The only thing surprising to me about that is there's not at least 4 or 5 different opinions from 3 different law tubers. That is the only thing surprising in that sentence to me. That 3 different law tubers have only given you 3 different opinions. We're not trying very hard. Yeah. Yeah, that's the only, yeah. Yeah. I mean, I'll take judicial notice of it as the trial court of uncivil. I'll take judicial notice of it, and I will certainly factor the respective opinions of our companion states, of our sister states, as we say. I will certainly consider the learned opinions of the Supreme Court of Wilson and the Supreme Court of Kennedy as I'm doing my Doe-Bear Fry analysis. But once I make the determination that this witness is going to be allowable, because obviously they're testifying or this whole conversation's moot. Once I make the determination that they're allowable and I'm allowing the scope of the testimony, I have no problem with you. Like, I have no problem with the person offering the testimony saying all the foundation questions. Like, they can ask all the foundation questions. Like, isn't it true that your testing is reliable and trustworthy? Isn't it true that, this institute and that institute and this paper and that paper, and isn't it true that, this expert and that expert, they all agree with you? Isn't it true that this learned treatise and this publication, isn't it true that you got the fucking Nobel Prize for this wonderful research? Right? I have no problem with all those foundation questions. And on cross, I have no problem with the other foundation questions. Isn't it true that, that the American Foundation of whatever that you're accredited by actually is a cult and meets in the basement of, of a pizzeria in DC? And sorry, and the New England Journal of Medicine and Nature and whatever say that you're full of shit, and also you use entrails as part of your methodology. Isn't it true that you sometimes use the entrails? Hey, we only use the entrails when we really need to. Okay, most of the time it's tarot cards. Thank you very much. I have no problem with all those foundation questions. The problem I'm having with is sort of the ultimate question, right? The ultimate question of, isn't it true that the courts of Kennedy and or the courts of Wilson have said that you're great and or a con artist, as the case may be? That's the problem I'm having. Yeah. We have to consider the strong possibility that one or other of the courts of these respective states have their head up their ass. There is a very non-zero possibility that one of these 2 courts have their head completely up their ass. We know that much is true. We know that very much is true. And so, like, I have to allow this. I have to allow the learned opinion of my sister state when it's bullshit to be used as a cross-examination question. I don't know, ma'am. I don't know. I'm not feeling it. I'm not feeling it. Their judges are drunk a lot. The judges made their decisions using entrails. It's right in the rules of appellate procedure. Yeah, I looked up the Supreme Court. I looked up the rules of appellate procedure in the Supreme Court of Kennedy, and I can't help noticing Rule 13. Rule 13 on Wednesdays we make decisions by looking at pig entrails. Yeah, I don't know why they like that. I don't know why they put that in their rules of procedure, but I'm not really sure that I should allow that question. I'm not really sure I'm feeling it over here in the state of uncivil. So we need a panel of lawyers. We need a panel of lawyers because the only thing because my bet is we'll have more opinions than lawyers by the time we're done. That is my working bet. We'll have more opinions than we do lawyers. Because that sounds like something that definitely was going to happen. Yeah. Yeah. I mean, it's persuasive authority as to this. I'm not denying it's persuasive authority as to the Doe-Bear issue. It's persuasive authority. I'm not denying that. I'm not denying that I should, factor this into my Doe-Bear analysis as the trial judge of uncivil. But having made my decision in my learned way as I do, having made my learned decision in the way that I do, that I then have to allow the question to the witness seems like a step much. So I'll absolutely take judicial notice of it. I have no problem with that. I'll take judicial notice of it all day long. I'll take notice of their respective opinions and I will weigh them carefully because I'm a good judge. I will weigh them carefully. And then I will come up with a decision that will make no one happy because that sounds probably pretty likely. And, then we go from there. And then what do we do, right? Meanwhile, at the U.S. Supreme Court, ... Yeah. I need a crim law professor. I need more than one crim law professor. Andrea Burkhart would be the best, probably. Andrea Burkhart, because she does criminal appeals. I would, yeah. What does Andrea think about this? She would be the one. She would be the person I'd go to for help. Is Andrea streaming? I need help. Can I get on stream with her? Let's see if she's streaming. Let's see if I can get on stream with Andrea, and we go for support. I need support. Can I get emergency support from Andrea Burkhart? She is streaming. Okay, how do I get her attention? That's the real question. This is going to be challenging. I don't even know how to do this. Is her husband in chat? Because I could ask him to ask her. I don't have her phone number, which is sad, or I text her. I don't really have any way to get in touch with her. This is unfortunate. I could tweet at her, but she's not going to necessarily see it. I'm out. I don't know. I need an emergency intervention with Andrea Burkhart. Yeah. I need Andrea support. Look in Discord. All right, cool. Give me a stream link. I will give you a stream link. Let's see if we can get Andrea Burkhart in here to render an opinion on this. And then I will ask really stupid questions like I've been asking you guys. I will ask her the same stupid questions and I will walk her through my same stupid logic and she can call me an idiot. And that'll be interesting. She is a criminal appellate specialist. So she's the most likely of us to know the answer. It's either that or Steve Gosney, but he doesn't really stream these days. Yeah. Either I join her stream or she joins my stream. Either way, I can also join her stream. Either way, yeah. So we'll take Andrea Burkhart. I will ask her stupid questions, and she will give me answers, and we will proceed from there. And it's also quite possible that there's just a difference between buttressing and impeaching. That the rule just doesn't work both ways the same. So maybe it's just the rule only works one way. Sometimes rules only work one way. So maybe I can't ask the buttressing question, but I can ask the impeaching question, which seems odd, but maybe that's the answer. Yeah. So we'll see. We'll see if Andrea gives us help. We need Andrea's support. I don't know if we should flood her chat, Mandy. That doesn't necessarily seem like the most polite thing to do. I don't want to flood her chat like I'm being demanding. I don't know if we should do that. I mean, I want to grab her attention, but I don't want to seem like a demanding prick. Yeah, no, I understand using a prior funding of unreliabilities and buttressing, Bama. I understand that. In my hypothetical, we have one buttressing opinion from a Supreme Court, and we have one contradictory opinion. The Supreme Court of Wilson has said this is the greatest expert that's ever crossed the face of the earth. The trial judge of Wilson said this is fantastic, wonderful, and brilliant in every way. The Supreme Court of Wilson has also said this is the greatest expert of our times on a one-to-one issue with the same expert, by the way, on a one-to-one issue. The Supreme Court of Wilson has said this is the greatest expert ever. We think that they're great and wonderful in every way. We're thinking about creating a monument to their glory in our courthouse. We're literally thinking about just putting a picture of them as a rule. Rule number 15 of trial practice, literally just a picture of this person because of how great they are. They are the Venetian man of experts. Everything they say is great and glory and wonderful in every way. Meanwhile, the Supreme Court of Kennedy has said that this is trash fire and a disgrace to anything called science. We are literally puking our guts out. It is horrible and disgraceful in every possible way, and an affront to all that is good and righteous, and possibly also an affront to God. And so now I'm the trial judge of the state of uncivil, faced with these twin opinions from the Supreme Court of Wilson and the Supreme Court of Kennedy. And what am I supposed to do now? And I do my Doe-Bear/Fry analysis as I do, and I'm like, yeah, this expert's fine by me. And they're going to testify. And now they're on the stand testifying in a one-to-one issue, the same expert, one-to-one. And now I have these twin things, these twin issues. So do I have to allow the person offering the testimony? Do I have to allow the person offering the expert to ask the question in the end? Isn't it true that the state of Wilson, in substance, not necessarily in form, in substance, do I have to allow them to ask the question? Isn't it true the state of Wilson says that you're brilliant and wonderful and great in every way, and they're thinking of creating a monument to your honor, and you are the greatest witness that's ever happened in the history of time, an archetype for all seasons, the Venetian, blah, blah, blah. Do I have to allow that question? And also on cross, do I have to allow the question, isn't it true the state of Kennedy says that you're a jackass con artist who gives snake oil salesmen a good name, and so forth and so on? Do I have to allow these twin questions? Do I have to allow either question? Do I only have to allow the one question? I have questions. What do I have? What am I required to do here? What am I required to do? Jeff Burkhart's in Andrea's chat. Okay, let's see if we can get Jeff to contribute. Yeah. Let's see if we can. Yeah. Let's see if we can get Andrea to help. We are help. We need help. Yes. Let's see if I have Andrea's. Do I even have her Twitter DM? I do have her DM. I have a question on this legal issue that is being discussed. I need help. Smiley face. Can I come on stream with you and discuss I need a crim law expert. Smiley face. Or you can come on stream with me. Either way, I don't want to be imposing. If let me know. No, smiley face. Okay, great. So I've now tweeted Andrea Burkhart or DM'd Andrea Burkhart, and we'll see what she says about this issue. Yeah. I'll also say, can you please ask Andrea to check her Twitter DMs? I need a second legal opinion, if possible. Smiley face. Okay, yeah. Let's see what we can do here. Let's see what we can do, and I'll walk her through my hypothetical, and she can tell me how I'm being an idiot, or not, as the case may be. I'll walk her through my stupid hypothetical with my stupid hypothetical states. Franklin is one of the states they usually create on the bar exam. Franklin is one of the fictional states. Yeah, so the Supreme Court of Franklin. What is like one of the other fictional states that they use on the bar exam? States used on bar exam. Franklin is one. What is like another one? Olympia. Yeah, so we'll use the states of Franklin and Olympia because those are states that they use on the bar exam. Okay, so we will rewrite to use the states of Franklin and Olympia so we can be like a bar exam problem and one of the cool kids. We are very politely we are waiting on this court to resume, and we are very politely trying to create a conversation with Andrea Burkhart because I need a second opinion. Possibly a third. We'll see how it goes. One step at a time. Yeah. Yeah. Does anyone know a crim law professor? Any of you guys, law students, have a crim law professor that can jump on stream real fast? Preferably someone who knows something about expert evidentiary issues would be a nice bonus. Can I do a quick recap for those who just joined? Not really, no. Yeah, we're trying to figure out this legal issue that's being discussed in court. I think Alessi's wrong. But I'd like to know what someone else thinks. Yeah. I wonder if Nate's available. Let's see if we can get Nate. I'll text Nate and see if he can hop on stream. All right. This is I don't know if Nate would know the answer, but it's worthy of trying. Runkle would have a good opinion. Well, no disrespect to Runkle, but he may not know just because he's a Canadian lawyer, and God knows they don't use either doe bear or fry in Canada. I don't know what they use in Canada. Mooses, maybe. So, yeah, I don't know that Runkle is necessarily the best source for this. Andrea or Steve Gosney would be the best source for this. Andrea is my go-to on this kind of thing. Yeah, something. I'm definitely, yeah. I did tweet Jeff, didn't he? Did he tweet me back? I don't even can't find my own comment right now in Andrea's chat. Did I send Jeff a comment? I thought I did. Yeah, I did. Let's see if Jeff's wrote me back. Jeff may not have even seen it because the chat is going too fast in Jeff's chat. Okay. Court's back, so I don't know what the fuck's happening.
You have joined the meeting as an attendee and will be muted throughout the meeting.
Great. Thanks.
The host would like you to unmute your microphone. You can.
All right, I appreciate the time. I appreciate people's patience. So, in reviewing the rules, I look at Rule 2. So, Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so, upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So bring the jurors in, please.
I mean, that sounds right to me.
Unmuted.
That sounds right.
Christy, do you want this under that?
It sounds right to me. But I could have my head up my ass. But yeah, it sounds right to me. You can ask all the foundation questions. You just can't get to the actual opinion itself. That sounds right in my head. So, yeah. I'm not sure how much it matters practically, but because you can ask every foundation question, you just can't ask that ultimate question. But I don't know how much value that really had for you in the end. It's very marginal, but it's an interesting technical issue. The fact she's using her own app, I don't think is material either way. I don't think that matters. That's her own app or not. I don't think that matters in the analysis.
Put it back in session and ABC.
Jurors, I appreciate your patience. So your next witness, Mr. Brennan?
The Commonwealth calls Jessica Hyde.
I'll keep an eye out for Andrea, but she's probably going to stream the trial and not be able to talk right now. So we may not be able to. We may not be able to talk, but yeah. You can't ask the ultimate question, isn't it true that the court in Maryland said blah, blah, blah? You can't ask that question. That's what I mean by the ultimate question. You can't ask the question, that question.
Follow me, please.
Andrea said the specific rule that says it shall come in takes precedent over the general rule. Yeah, but shall come in for what is the issue? Yeah, I understand it has to come in. I understand judicial notice, but come in for what is the issue? I'm not denying it comes in, but for what purpose does it come in? That's the question. Yeah.
Raise your right hand, please.
Was your method ever rejected? You might be able to ask that. Yeah, you might be able to ask that question. That seems maybe okay. I'll have to get back to you.
You saw, Mr. Wade, the evidence
It'd be objection leading? No, it wouldn't, because it would be the defense asking the question. Leading is permittable. So the leading is not the problem.
The court and jury in the case now and hearing the truth, the whole truth, and nothing but the truth, so help me God.
Yes, I do.
Good morning.
Good morning. Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica, space Hyde.
What do you do for a living?
I'm a digital forensics examiner. I'm also an associate, I'm also an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University,
I'm
not
sorry.
Georgetown. But thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, et cetera.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm so sorry.
What does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are 3 types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. A master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC3 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, you know, if you think about it, if on your phone you can go to the Google Play Store or the App Store, and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user initiated deletions of phone calls on the device.
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And in engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. In local time here in Norfolk on January 29th, 2022 from the device I was provided, yes. Not the device, the forensic image, for clarity.
So before we get to the two opinions that you were asked to consider, or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2:27 time frame. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually three, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran two different algorithms, they both matched. Additionally,
Is it just me, or is she talking down to me? Because I feel like she's talking down to me. Okay. All right.
reviewed the PDF that was received for signs of alteration. The PDF that comes with a Gray Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns the Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022 at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual, and on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs which is Adobe's format of markup, and I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the gray key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that
Yes.
correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted, or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
You use the term artifact. What does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo, any action you take on your phone may create an artifact.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So for clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town, I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search Hoslong to die in cold. However, that timestamp isn't about active searches, it's about the time that a tab was either opened or moved to the background. So Hoslong to die in cold is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab or you can open a new tab. A new tab was opened at 2:27 a.m. and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background or, if it's never been moved to the background, the current search. So the time, in the instance of the It's Raining Men video, is the time that that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is Hoslong to die in the cold, because that database holds the current search, it constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of
I
the different
did. I did
databases?
put it together an exhibit that would show that.
May I approach?
Yes.
Handing you a piece of paper. Do you recognize that?
I do. This is table 1 from the first report I created on this case on the phone that I was told was for Jen McCabe.
Is that the exhibit that will help you explain?
It will.
I move this to evidence.
Who are you approaching? Or if I'm going to object if you want.
You can come on out.
Okay. Well, this is mind numbing. Okay. What were we talking about when my brain was working? Yeah, okay. Well, hmm. 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 My brain is like turned off. It could be the up talk. It could be the slightly condescending way she talks, which could also be the up talk. It could be the onion hat. I'm not sure. It's one of these things. My brain is no longer working. Court is, they're still doing ceiling fan. Yeah, toothpicks for the eyelids. It's something like that. Makes you feel better. It's mind numbing. I feel my brain bleeding. Yeah. She's a professor. How do our students pay attention? And how do I should definitely be applying for professorship gigs. I don't know if I need to send in applications or something. But if this is the quality of professors, I feel like I can do better, man. I'm not necessarily saying I'll be the bestest professor ever, but I think I can. I think I can hold my own. Anyone need a law school professor? Anyone know a dean of a law school? Asking for a friend. I'm available. I'm particularly good at con law, but I could do pretty much any first year subject in a pinch. Property law would be good. Torts. Yeah, torts or property law, probably. Probably not Civ Pro. Yeah, Crim Pro probably wouldn't be my first preference. So what would be good? Yeah, con law would be good. Torts would be good. Property law would be good. Probably not contracts. Although I could do contracts in a pinch.
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, it was able to, on that date, be able to determine that Safari was the application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search of 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also used Magnet Axiom.
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image, and that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize, I also used ArtX and Mushy. But the, I'm sorry, ArtX is capital A, lowercase rt, capital E, lowercase x, and then Mushy is M-U-S-H-Y. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrate, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundation's paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
The software updates all the time. Typically, we get an update about once a month, and to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrite tool to analyze the 227 search, did the search How Long to Die in the Cold have a timestamp on it?
There are actually multiple artifacts for How Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that How Long to Die in Cold. Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Celebrite.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, How Long to Die in the Cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as How Long to Die in the Cold with a timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain.
Parsed or carved?
So
Parsed or
parsed
carved?
means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out and went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions.
It's been a long time since I did my computer science degree. Is carve a term of art? I'm not sure it is. Is anyone here do computers? Is carve a thing? Am I just forgetting a thing? I know parse. Is carve a thing? Or is she just making up shit? Yeah, okay. I just wanted to double check. I just wanted to double check.
Tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrate and it showed this timestamp as well as the phrase, how's long to die in the cold, where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab, and then I make another search in the tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded, and it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when this search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the knowledge CDB. The knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace?
The cache contains suggested terms? I don't think it does.
Different parts of the computer or the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome. and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how's long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden?
I don't understand the question, yeah.
Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair, understood. So all of those databases I was just mentioning before, we're looking at all the parse results from all of those, and I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in.
You know, I'm reminded of that guy who went to a job interview, but there was a mix-up, and they put him on air as an expert. You guys ever hear that story? The guy went for a job interview for some job, and somehow there was a mix-up, and they wound up putting him on air as an expert, and he basically had to fake his way through the entire on-air discussion, go through it. This woman reminds me of that guy. Yeah, that's who this woman reminds me of. Yeah.
The tabs for BrowserScapeDB, Cloud Tabs artifacts, HistoryDB, Mobile Safari plist, Knowledge C, each one of those, and then I was combining them to timeline out the activity.
At 62351, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari plist.
Can they appear in different rooms in the data bank, in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB,
I'm glad you love it.
Trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD, CIKLD, CIKD, CIKD.
And finally, at 62447, did you identify any artifacts with that search that appears with the timestamp of 22740? Did you find the same?
Correct. At 624, we have two timestamps in the same two locations for how's long to die in cold, the Knowledge C and the Mobile Safari plist.
So based on your analysis in that issue, did you come to an opinion whether or not the phrase how's long to die in cold was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no?
Can you repeat the question,
Yes.
please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase how's long to die in cold was searched at that timestamp tab of 2:27:40?
Yes, I came to an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to the opinion.
I'm sorry?
What's wrong with the question?
I'll see you at sidewalks, Mr. Lester.
Yeah, I don't understand the problem. What is your opinion is an open-ended question. What is the problem with the question? Yeah, I don't, it's like, yeah, he's like, how do you want me to rephrase that? I'm confused too. I'm confused for Brennan. It's like, am I not allowed to ask the question for some reason? If I'm allowed to ask the question, I'm not sure how I'm supposed to rephrase the question. I'm confused by that. Yeah. She's an expert witness, right? She's allowed to give an opinion. So what's your opinion? Yeah, I don't understand the problem either. I'm confused. I don't understand. Yeah, I don't understand what the problem is either. She's not allowed to give an opinion? Then if she's not allowed to give an opinion, then I don't know why she's here. Because she's only here as an expert witness. She's not a fact witness. She's an expert witness. So if she can't give an opinion, why are we even here? I'm so confused. What's the problem with that question? I got nothing. Has she been qualified as an expert? You know, strictly speaking, I'm not sure that they actually ever technically qualified her as an expert. That's fair. I'm not sure that at any point Brennan actually asked to formally qualify her. That's a fair point. So assuming that didn't happen outside the presence of the jury, you're correct. There's a foundational question that needs to be asked to certify her. That's fair. That's fair. If that's what's going on, fair enough. Is it not leading? No, it's not leading. Leading suggests the answer. What is your opinion is not leading. That's about as open-ended as it gets. Yeah, so the fact that she was never formally entered as an expert, although I'm not really sure they did that in the first trial either. I'm struggling to think if they if they actually asked that question of any of the experts, or they just kind of took it as a given. It's like this judge didn't really require that step because it was sort of implicit. I don't know. Yeah, I don't know. But you're right. They never actually asked the question to formally admit her as an expert. Fair enough. The judge is going to say yes, though. I mean, obviously, if the question is, can I have her be an expert in digital forensics? The judge is going to say yes, and then she'll give the opinion. So, whatever. But we got Spinny Fan. Spinny Fan still spins for truth. But they're having a debate about something. I don't know if it's about a scope. I don't know if maybe they're trying to redo the Daubert thing. Are they trying to have a Daubert hearing right now in the middle of the witness being on the stand? Does the defense want to voir dire the expert on the scope of their expertise? Does the defense want to get up and ask some voir dire questions? Want to do a voir dire in front of the jury? That'd be good. Haven't seen one of those in a while. Yeah, maybe that's what the defense wants. Maybe they want the defense the person do it, and they want to do a voir dire in front of the jury, or they want to do the voir dire outside the jury. One of the two. Voir dire in front of the jury, voir dire outside the jury. Are we doing a doe bear now? What are we doing? I want to go back to discussing this evidentiary issue with our states of Franklin, Olympia, and Columbia to make it a bar exam problem. We'll have the states of Olympia and Franklin make a decision and have made decisions, and the state of Columbia has to figure out what to do in light of the decisions of Olympia and Franklin. Those are the states they use in the bar exam. So we'll do it as a bar exam problem. It's a tri-state area. The tri-state area of Olympia, Franklin, and Columbia. Yeah, good times. So good times on the bar exam. Yeah. What he just said is bullshit? Yeah, pretty much. Ceiling fan. Globe is back with ceiling fan. And then we got some wall lights. Wall lights are trying to enter the picture. Next to outlet, we got little baby wall lights. Are those little baby lights babies of lamp? Do you think that those are its offspring? Does lamp acknowledge the lamps? They're twins, apparently. Does he acknowledge they're the twins, or is he a neglectful parent? What are we thinking? What is also up with Outlet? Outlet looks surprised. Outlet is surprised at how Lamp is behaving. Is Outlet the babysitter for lights? There are two outlets and two lights. Are those related? Are those twin parents of the twin children? Why is there also an outlet so high on the wall? Who's using that outlet up there? All right, what are we doing?
You've explained to us the analysis you engaged in and the process you engaged in. In forensic data analysis, is there a methodology that you use, not just looking at the printout of the programs, a methodology you use that is accepted in the industry for experts to analyze this data and come to your opinion?
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did,
That's not quite the same thing.
Can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence, who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, organizational scientific...
Bullshit. You are name dropping. Bullshit. If NIST has a standard, what is the standard? Where is the standard published? Where is it? You just are just doing that. I'm a member of NIST, which could mean anything, and therefore it's accredited. Yeah, bullshit answer. I want to see the white paper from NIST. Yeah, show me that.
Area committees, OSAC, Digital Evidence Subcommittee. where we also produce guidelines such as the data set guidelines for generation, the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How
Sure.
about through Safari?
For Safari, there are multiple.
Yeah, so the defense challenged the fact that she'd never been admitted as an expert. That's what that happened during the sidebar. And so now we're having to work our way through the steps to formally admit her. And we're working through that steps. And yeah, I have questions. The way she's phrasing it is just like, well, I'm part of the subcommittee, so therefore I'm great, right? I helped draft it. It's like, okay, but the draft was approved by somebody. It was actually published by NIST, as if it was actually like accredited by NIST. Then where's the paper? Where's the white paper? You know, where is it? And be like, oh, here it is. Here's the standard. I mean, I wrote it, but still, I mean, it was accredited by NIST. I mean, so, you know, okay. But it sounds suspiciously like she's part of a group project. She's part of a group project, and I'm not feeling that. Yeah, I'm not feeling her answer here.
Different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is their, 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
Yes.
Is that correct? There are multiple, I've taken courses throughout my master's program, courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology?
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the...
It's not just me, right? It just feels very buzzwordy. It's not just me, right? Please tell me I'm not alone.
Most authoritative, because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions, is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now you
What? What?
You share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term "house long to die in cold."
That is correct.
Now, I want to ask you to a reasonable degree of forensic.
Well, I'm an expert in law. I studied contracts and I studied consideration and also took the tort and took a class on the Posner and and took a UCC Black Law Dictionary. Okay.
Forensic data, scientific certainty. What is your opinion about whether the phrase "house long to die in cold" was made at the time of the timestamp 2/27/40?
Yeah, I still think.
It's the last time, Mr. Bessie, on this issue, okay?
I mean, still you still have to formally admit her as an expert, and still I share the it's I want also can I voir dire her? I share the concern here. Mod chat, let me check what's going on in mod chat. Give me a second. Oh yeah. Another sidebar. Sidebar. Hey, Bama Law, are you a lawyer? And if so, do you have a particularly learned opinion on this issue of the? I'm not. I didn't mean to insult you. I just didn't know a better way of phrasing it. I apologize if that was insulting. Do you have an opinion you'd like to share on this whole evidentiary question that we were sort of debating? Because if you do, we could have a discussion. Maybe I could use a second opinion if you have some, thoughts to add to the equation. Oh, mod chat. Oh, I'm sorry. I was trying to do too many things. This explains the issue. Okay. So there's okay, I'll read this while we're waiting. I'll just read it. So this is apparently a page from this Maryland decision thing. So I'll just read it. This is a page, in isolation. So obviously, we'll take it with an appropriate grain of salt. But the page says, from Maryland, court said, Miss Hyde testified that her personal real-world scenario testing was the basis for opinion the methodology in the case was reliable. She testified why she didn't conduct testing on the device, whatever that device would be in this case. She used her notes and her data set from her personal testing. However, in the case in question, the phone was an iPhone 6S running some iOS with no SIM card, had not been wiped of pre-existing data, and was not jailbroken. The phones were not the same model. The operating system were not the same, with the exception neither phone having a SIM card. Other settings are not identical. That sounds like a lot. Notably absent was testimony as to similarities or parallels that exist between the iPhone 6S and 7, which would explain yielding the same test results. She did not testify as to any similarities or parallels between the systems, between the two versions of the iOS, which would explain why the testing would yield the same results. While Ms. Hyde explained her testing done for peer review purposes, she provided no correlation to explain or acknowledge differences or similarities between the devices. Moreover, she did not retain her notes, her data set, or computer used to conduct her testing, which forms the basis of her opinion. She acknowledges that Apple is continually updating its operating system. Under the circumstances, the court is left to rely on or accept the ipsit dixit opinion of the expert. Ouch. Ouch. Because I say so. That's harsh. That is harsh. Oh man, because I say so. Holy shit. The issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. Well, Ms. High is certainly knowledgeable and subject to significant location data. She acknowledges limitations due to Apple's proprietary algorithms, such as she's unable to determine the specific sources of location data which make up significant locations. She does not know the number of data points on Apple is using for significant and blah, 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 and so forth and so on. So the Maryland court was pretty brutal in relating to the scope of her expertise. Ouch. Jury isn't watching this. The jury is watching this. The jury is there for this entertainment. So the Maryland court was not thrilled. And those are perfectly reasonable things by the Maryland court. Those are perfectly reasonable considerations. 2 different phones with 2 different operating systems, and you haven't shown that they're the same in this domain. And so, and also you didn't retain your devices and didn't retain your stuff. And so, it doesn't feel very reliable. It feels like the Maryland court has some thoughts on the issue that are not necessarily invalid. You'd allow the impeachment? I don't know. I mean, I'd allow them to ask every one of those questions. Isn't it true that there were different operating versions? Isn't it true that those differences matter? Isn't it true that, you don't know that? Isn't it true you didn't I'd allow them to ask every single one of those questions. The only thing I wouldn't allow them to ask is, isn't it true that the court of Maryland said that you're full of shit? But all the foundational questions, I'd allow them to ask those. That's fine. But I didn't need the Maryland court to do that. They could have asked all those foundational questions anyway. So the Maryland court doesn't get you anywhere. It's like, yeah, you could do it, but you could have done it without the Maryland court. So, whatever. Yeah, the thing you want to do is you want them to ask, didn't the Maryland court say you're full of shit? And I don't think I'd allow that question.
Ask you for your first.
All right, go right ahead, Mr. Brennan.
I'm now going to ask you for your first opinion. So you shared that you have an opinion about whether that timestamp 22740 was, whether or not that was the time the search "How Long to Die in the Cold" occurred. Can you tell us to a reasonable degree of scientific certainty your opinion about whether that search, "How Long to Die in the Cold," occurred at 2:27:40 a.m. on January 29th, 2022?
Same objection, Your Honor.
Okay, the objection's overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Do you have an opinion to a degree of scientific certainty whether there was any other searches similar to "How Long to Die in the Cold" that evening on that tab?
Objection, Your Honor.
I'm going to allow it.
I bet you are.
May I first inquire, you meant morning, as I
I'm sorry,
assume?
that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train of
Do you have
thought.
an opinion to a reasonable degree of scientific certainty whether there were any other searches on that tab before the final search at 6:20?
I have to say that this woman is not exactly instilling me with a whole lot of confidence in any event. She isn't striking me as super duper. I as a judge right about now, I'm thinking to myself, should I rethink that Dober decision? That Dober-Fry decision? Should I be rethinking that Dober-Fry? Is it too late to strike this witness's testimony completely? Is it too late for that? Yeah.
24:47, "How Long to Die in Cold."
Same objection, Your Honor.
Overruled.
Just ensuring that I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Okay. Did you develop a chalk that I
I
showed
did.
you earlier?
Oh my God, the chalk appears.
Yes.
I don't care what the rules say in what state are we in? Massachusetts. I don't care what the rules say. I object to it being called a chalk. Call it like an exhibit, like a normal court. Who the fuck decided to call it a chalk? I object. Call it a demonstrative aid. Call it that. Don't call it a chalk. Fuck.
Again, I show you. Same document, you recognize it?
Yes.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I'd move, subject to redaction, that this be introduced into evidence.
Your Honor, I have no issue with regard to the redaction aspect, but consistent with my prior objections, I would object to that.
Okay, I'm going to allow this into evidence. You're
I
right.
bet you are.
Thank you, Your Honor, appreciate it.
Exhibit 82.
Madam Clerk, 82?
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay?
Could we enlarge the first two? And we're going to need to get the right column in if we can, please. Thank you. Ms. Hyde, can you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left it says 2:27:40 a.m. and then under the search term it says How's Long to Die in Cold. How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column, it's a little bit cut off, the browser state db-wall file, that database does store, how the data is stored, the search term How's Long to Die in Cold with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact, the cache record.
Mm-hmm.
What is the term, and what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, how long does it take to digest food?
And then under that, 6:23:51, it appears it says a recent web search, and the spelling is changed. How long, TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as how long, TIDINCIKD, which that is available to us in the Mobile Safari P-list, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column.
Is it too late for me to ask to transfer professors for this course? I just don't think our personality styles are working.
At 624.47, we again see house long to die in cold. And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 624.47 and also appears up at 227.40?
As mentioned before, through testing of the artifact for browser state DB, that artifact will hold the most recent search that happened in the tab. So it is logical that HOS long to die in cold was searched at 624.18, tracked in that mobile Safari P list, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for browser state DB, which again has the time that the tab was opened or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 227 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
You offered that the house long to die in cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that HOS long to die in cold was searched at approximately 6:24 a.m.
Now, moving on from the 227 search, there are 2 other issues that you were asked to analyze. We talked about that at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, "house long to die in cold," was user deleted on that device.
So there's 2 really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important, so we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that -wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has 2 versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant.
Oh dear.
And we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log.
What?
The server grabs it from there. It's where data sits before it goes to the table. Just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders
Help me.
waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. Waitress comes over, this pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We're moving. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image, the applications are still open, so we have those WAL files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table. But it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the WAL file. Just because it's in the WAL file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be that WAL file can contain deleteds and food or data that hasn't yet been delivered to the database. So the WAL file consists of both. So an assumption that the data was deleted just because it's in the WAL file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains this exact presence for SQL.
If you're telling me in a peer-reviewed paper you talked about the restaurant, I want to see this paper.
Databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the WAL file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the WAL file. That particular item is a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Ha's long to die in cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the WAL file elements such as the search for the YouTube video, It's Raining Men, because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the Ha's long to die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the WAL file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the WAL file for that reason. It doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web, that Safari search is characterized as deleted?
The tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parse, so every tool chooses to do that differently. That does not mean deleted, it means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
an examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the data set generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting because of what it appears in the forensics tools and additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count too, and they'd get their own logs. So when we look at the database for the number of calls, between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until noon. So we can actually see all of the calls. They're just not on the call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining is recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
So do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you.
Mr. Madison, what you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it. I award you no points, and may God have mercy on your soul.
Okay, a simple wrong would have done just fine, but
you remain one.
Scheduling and a few things.
uh, mm, uh. Okay. Let's schedule the afternoon stream. Lord. Uh, what is today? Okay, it's day 11. It's the 7th. Change the thumbnail. Are they coming back? What time are they coming back? Someone said 1:30, I think. Someone say they're coming back in 30 minutes. $30? Oh my God, really? I'm not going to be back on stream in 30 minutes. There's no way in this world. All right, I will schedule it for 30 minutes, but I'm not going to be on camera. There's no fucking way. You better schedule, you bitch. Don't do what you did yesterday. I swear to God, I will kill something today. Don't you fail me today. I swear. Don't spinny wheel me. Don't you spinny wheel me. I will reach into this computer and I will reach right into your website and I will destroy you. Thank you. Thank you, sweet Jesus. Yeah, okay. I've been on civil law. Till later.